What's the number one mistake the disability carriers or plans make in their denial or termination letters? Have you ever seen the I Love Lucy episode where Ricky tells Lucy she's got some splaining to do? Well, if you've ever read an ERISA denial or termination letter, it's like a mashup. It's a horror show, a comedy, and a science fiction movie. You get to deal with the financial horror of a denial or termination, a crazy cockamamie reason for the denial or termination, and a letter that does not make sense. Now, under the ERISA rules and regulations that govern ERISA disability policies or plans, the carrier or the plan is supposed to do some splaining. They're required to provide an explanation for why the carrier or plan agreed or disagreed with the opinions of your doctors, the opinions of their liar-for-hire doctors, they're not so independent IME doctors. All that's got to be explained. Now, right out of the box, they're often going to reject your doctor's opinions. It might be the testing was normal, your examination was normal, your doctor's relying on your subjective complaints. You name the reason. They're also supposed to talk about the opinions of their liar-for-hire doctors. Now, they will go to great lengths to explain their doctor's opinions, why those opinions are better, right, and more believable than your doctor's opinions. You name the reason. Now, I'm going to attack the common failures that are the heart of the denial, and I'm going to be very aggressive about attacking these opinions, if you will. Now, part of the problem here is that the carrier plan does not supply you with the reports that are the basis of the denial. So you've got to ask for the entire claims file, which they have to provide for free. Now, their denial letter should be reviewed very closely, and what I do is review them and outline. I outline each reason for the denial, I summarize it, and then I go back to look at the policy plan or medical plan that's the basis of it, and then I go on and look at the medical records and summarize them to see what's been missed or cherry-picked. It's really important that you understand each document that's in that carrier file that's the basis of the denial or termination and why it should be taken apart with a fine-tooth comb. We want to identify those mistakes. We want to outline a plan to attack each one of those mistakes. Now, it might be that your doctor needs to address additional issues that have been raised by the peer-reviewed doctor or the IME doctor. You may have to undergo more testing. You may have to undergo a functional capacity evaluation. You may have to get vocational opinions. You may have to have other information such as statements or statements of family or friends. The medical or legal basis for this denial has to be attacked from beginning to end. If you have any questions about your rights to ERISA disability benefits, or if your benefits have been wrongly denied or terminated, you'll only have 180 days in which to file an appeal. The appeal is the trial of your case. There are no do-overs. Give us a call at 727-894-3188 to learn more about your rights to your ERISA disability benefits.